I think what would be helpful first for them is to have a little bit better understanding of sort of the arc of your career. If you could tell us, basically how you got started, all the different things that you have done, and then we'll go into more of the detail of this.
Okay. Well, thinking about this, it occurred to me this morning that it was 30 years ago, 1983, that I was sitting right where you're sitting, which is in the first year of law school. It seems like it went by fast. Let me tell you, when I was sitting where you're sitting, I wasn't really thinking about the arc of a career. I was looking maybe for a little spark at that point. I didn't really know what I wanted to do, and I'm sure that's true for a lot of you, that you've maybe came to law school with some vague notion, maybe that you're interested in litigation and you're not really sure what that entails, or you're interested in transactional work or public service of some kind, and you're not really sure. And that's normal, and I hope you all realize that. Some of you may have a clear idea. Maybe you have a tax lawyer in your family, and that's what you want to do. I was always amazed at my classmates who knew for sure in the first year what they wanted to do. I always thought, well, how do they know that? And I came from a family, we didn't have lawyers in the family. I think I was the first one. So I didn't really have those kind of role models. And so one of the things I hope you're doing as you go through this course and other things during your time at Mercer is kind of sampling, going to talks, talking to people when you're interviewing for positions, meeting lawyers, and getting a sense and trying to find some of those role models. When I graduated from law school, which was 1986, I went to work in the U.S. Attorney's Office in Chicago as a federal prosecutor. And I was very fortunate. The reason I got hired was that the Justice Department at that time was growing. The Justice Department in Washington has these branch offices, the U.S. Attorney's offices around the country, and they were expanding, and they were hiring at that time so many people that there was room for someone who was right out of school. And I had been an intern in that office. I did that just on a lark, saw a sign, wrote them a letter, got an interview, and the next thing I knew, I was an unpaid intern doing it for no course credit or anything. I was just going in the office and working in the U.S. Attorney's Office, and that led to a job interview eventually and the opportunity to go there. I was lucky because I didn't get pigeonholed, as sometimes can happen, and there's nothing really wrong with that, but to be a prosecutor with a certain type of case, like a drug specialist or organized crime or something like that, I ended up not getting pigeonholed, which was great. So I got to do a variety of things. You do a lot of routine cases that are not very glamorous, like somebody steals somebody's treasury check out of the mail, and you prosecute them for that. But I got to do some pretty large-scale drug cases. I got to work on some police and judicial corruption cases. I got to work on a big undercover operation investigating fraud in some of the financial markets in Chicago. And so I had a real variety of cases that I got to try and work on appeals. The thing that was really a gift was at a pretty early stage, I got to do some supervisory work, which was like a dream. If you're really interested in criminal law, that kind of position is great, because what you do is you're kind of an open door consultant. If someone's going to prosecute a case who's under your chain of command, they will write up a memo which you review. If they're going to try a case, they're going to have a conference to strategize, and you'll be involved in the conference. So with the supervisory work, it kind of like is a mushroom cloud. You just see so much stuff. And usually stuff doesn't walk into your office unless there's some interesting issue. The really easy ones, the prosecutors take care of on their own. So that was a real blessing to have that experience, and it actually was particularly great because I eventually decided to go into teaching. And I say decided to go into teaching, decided to put my name out there to try to get a teaching job, which I was very fortunate to get here. And the supervisory stuff was a great preparation for the classroom because it gave me a really large bank account of experiences, both firsthand that I was involved in and secondhand as a supervisor, and I think was good preparation for teaching. Since I've been at Mercer, I've done some law practice, I've done some appointed cases on the defense side, in the district court and in the Court of Appeals, and I'm going to be doing some more of that. I was talking to the judges downtown, and I think they're going to funnel me some more cases to work on in the near future. With the blessing of the school, I've been able to do some government work since I've been here. I came in 1994. I did some kind of special prosecutor work during one of the independent counsel investigations of one of the members of President Clinton's cabinet. Did that for a couple of years, and I was continuing to teach full-time, but was commuting back and forth to Washington and doing work out of here. And then in 2003, the school was really very generous. They let me go on a leave of absence for 2.5 years. That's almost as long as it takes to go to law school, so that's a good chunk of time. And they let me go back to the U.S. Attorney's Office in Chicago, where I served as the appellate chief. And that was another supervisory job, which was just a wonderful immersion in a whole variety of different kinds of cases. And I also I served as kind of legal advisor, besides doing the appellate work, which was a lot of editing of briefs and going to oral arguments and stuff in the Seventh Circuit Court of Appeals up there in Chicago. My role was to be kind of an advisor to the office on issues. So I did a lot of walk-in consultations, went to a lot of meetings, and basically got called in to participate in a lot of really interesting cases. So again, it was a great immersion in a whole broad range of cases. And then I think Pat wanted me to mention, while I was in Chicago, the fellow I was working for, a guy named Pat Fitzgerald, who was the U.S. Attorney in Chicago, he got asked to be an independent prosecutor, independent counsel type of position. They called him a special counsel, actually, involving this case where someone in the Bush White House allegedly leaked some confidential classified information about a CIA operative, and there was an issue of who leaked it and why they leaked it. And Pat Fitzgerald got appointed to handle that case and asked me to work on it. So starting in January 2004, while I was still away, I started working on that. And when I came back in the summer of 2005, I got appointed to it's like a part-time federal prosecutor position where I was working here teaching and working part-time for that investigation, which eventually led to an indictment of one of Vice President Cheney's staff and eventually his conviction at trial. And that work ended for me in about 2009. And so at this point, I've cut the tether. I'm not working for the government in any capacity, which is why I expect to hopefully pick up some defense cases.
Right, so that special prosecutor work in early, or during the Bush administration, that's what led to the prosecution of Scooter Libby. You had a particular role in that, because Scooter Libby wasn't the only one that faced consequences as a result of that investigation. There was a New York Times reporter. And I wonder if you could talk just a little bit about your role in connection with the dispute about the sources and the government seeking the names of the sources and what role you play.
Well, a leak investigation, meaning someone has some confidential information and then they leaked it to a newspaper reporter. If you think about it, how will I investigate this? You don't have to be Sherlock Holmes to figure out how to investigate the case. You know, the first thing you do is see if you can, you know, identify the person in the government, maybe through phone records or other things, who potentially had contact with the reporter. That's usually going to be a blind alley, and it was for us. Then the obvious thing is you go to the reporter. And of course, the press in the United States claims that, you know, in many jurisdictions to have a privilege, which means they have the right not to disclose information in certain circumstances. In the federal system, there are limits to that privilege. And so, and one of the limits is if there is a criminal investigation, it really needs to find out certain information so that it can complete the investigation to show that someone was guilty or someone was innocent, then the court can require a reporter in certain circumstances to turn over even a confidential source in the federal system. And I was involved with litigating that, involving several reporters, but ultimately a New York Times reporter, Judith Miller, resisted turning over information initially, and technically not prosecuted, but it was a contempt action. And contempt means, the contempt power of a court means that they can say to someone, I'm giving you a lawful order to turn over this information. If you refuse to do it, I'm going to put you in jail until you agree to comply with my lawful order. That's what the court's saying. And so the old cliche about contempt is that the person who's held in contempt has got the jailhouse keys in their pocket, because all they have to do is agree to comply with the lawful order and they can get out. And that's what eventually happened to her. After 85 days, she agreed to disclose the source. Eventually there was a grand jury indictment based in part on the information that she gave, and eventually she testified at Scooter Libby's trial for false statement, perjury, and obstruction of justice.
One of the things I know the students will be interested in is, given the kinds of things that you've done and the level at which you have practiced, can you talk a little bit about what law school did to prepare you or not, you know, in and out of the classroom for that experience? Full disclosure, we went to the same law school, so we didn't know each other. But what did the law school do to prepare you, and how did you use that experience to get ready to do what you did?
I think one of the really important things when you're in law school is to, obviously you go to your classes. The curriculum is, I think, pretty well put together here. There are a lot of things that you get out of your classes. We have some things that we do here differently. This is one of them. I didn't have a class. We didn't have a class like this. And I think this is a really great thing because it allows you, in the classroom setting, using some of your precious first-year class time, to get exposed to some stuff about the profession that you might just get in dribs and drabs or, you know, along the way otherwise. And I think it's an extremely valuable experience. And I would do it not just in the formal setting of the legal profession class, but in any informal way you can get it. I mean, one strong piece of advice I give to first-year students a lot is, and I guess I'll give it to you all en masse right now, is there are a lot of things that are going on in a law school and here in Macon, which has a pretty vibrant legal community. Take advantage of those things. You know, if there's a guest speaker, law day lunch, or that kind of thing, take advantage of as many of those as you can and go and meet lawyers and listen to the guest speaker, because you never know which one of those things is going to be the one that causes the light bulb to go on that says, you know, that looks interesting to me. And I've told Pat this story, I can trace to an exact moment when I first thought about public service and prosecution work. It was in a classroom a lot like this one at our law school, and I showed up a little late for a noontime brown bag to listen to a member of our faculty who was an older fellow, And he had actually, in World War II, had been, as a very young lawyer, on the staff of the prosecution at Nuremberg, which was the war crimes trials. You can imagine, for your first prosecution job, prosecuting the Holocaust, among other crimes. And he was a labor lawyer, actually, so this was not his field, and he rarely talked about it, I think, some out of modesty and some because it just wasn't his thing. And he was prevailed on to come in and to talk about this, his experiences as a young lawyer. And I went there, and of course I showed up at the last minute, and the place was just packed. And I remember sitting on the steps and listening, and it was spellbinding. I mean, he was talking about putting the prosecution together, and of course, he portrayed his role in it as very minor. I found out years later, reading, that it really wasn't so minor. I mean, he really was active as an assistant in the whole process. And like I say, it was spellbinding listening to it. And I remember thinking to myself, well, you know, obviously, I'm not going to do the Nuremberg war crimes trials or anything like it in all likelihood, but it sounded to me kind of like a noble calling. It sounded like good public service, and it sounded exciting, frankly, the whole idea of it. And so even though prosecuting someone for stealing a treasury check out of the mail didn't rise to the same level, it was the same kind of activity, and it was something that I was attracted to, and for me, that was when the light bulb went on. And if I had not gone to that little noontime speech, it could all have been different. It really could have been. So I encourage you to take advantage of all those experiences, both here in this course and the ones that just come up along the way, because one of those very likely could shape your whole career.
It's interesting you mentioned before the internship you did with the U.S. Attorney's Office. That's very common now and was uncommon when we were in law school. Could you talk a little bit about the importance of that both now and then?
It was great. I had done a little bit of summertime work for law firms, and I liked it. It was civil litigation type work that I was doing during the summer after my second year. The thing I liked about some of the civil cases was that it was like an investigation to figure out a mystery of what had happened. And that was the part of it that really attracted me. And when I signed up to be an intern during my third year in the U.S. Attorney's Office, I found out that these criminal cases, even the small ones, have that element to them. And it was very, very exciting working on cases. And I remember that I got asked to help with a trial. And at that time in the federal court in Chicago, I think it's still true, if you had a third year permit, like a license from the state bar saying you were a third year in good standing, you could actually participate under the supervision of a lawyer in court. So the first criminal trial I ever saw, from the very beginning to the very end, I was actually the third lawyer, so to speak. And of course, they gave me all the hard assignments, like it was an arson case, and I had to prove that it was an arson. Of course, it wasn't in dispute that it was an arson, so that was my job.
How'd you do?
I did. I proved it was an arson. But it was just fabulous experience being in the middle of the courtroom and working with two lawyers who were really good about taking me under their wing and showing me what to do, and it was very exciting. I remember I had to miss a lot of class because I was in this trial, and I went to one of my professors. It was a constitutional law class, a specialized one. I can't even remember which one it was, but I went to him and I said, you know, Professor, I'm going to be missing a bunch of these classes. And he said, well, what's going on? And I said, well, I'm actually the third chair in this arson trial, and it may take 3 weeks to try. And he said, well, you know, you're going to learn a hell of a lot more in that trial than you're ever going to learn in my class. And so go to it. And when you're done, you come and tell me what you learned, and maybe I'll get something out of it too. So he was very generous about that. I don't know how great my grade was in that course, but you know, that was the kind of experience that was. I mean, it was something that was really very exciting. So if you get those kind of opportunities through our practicum program, judicial field placement program, something you're doing during the summer, take full advantage, because that's the complement to your coursework. You know, some lawyers who are practicing have this attitude, oh, all that crap I learned in law school, I don't really need that. That's not really important. Now that I'm out, I've really learned. And I think that's really a skewed and flawed perspective. I think the way to think about it is that those practical experiences and some of the stuff you get in this course, that's the complement to the stuff, and both are important. And I think if you lack one or the other, I think you're going to be at a serious disadvantage when you get out.
Well, getting out is the next part I wanted to ask you about, because the law school, even the law school experience that has internships and summer employment, is not the same as being a new full-time lawyer. And so you went straight into the U.S. Attorney's Office. And I was wondering if you could talk a little bit about what that was like, and and let me phrase it this way: what surprised you, when you were there full time as a brand new lawyer?
Well, in answering the question, obviously this was my first job as a lawyer, and it was also, of course, learning about being a prosecutor. So it was kind of a combination. One of the things that I learned, and I think this is true for a lot of law jobs, if not all, is there are a lot of people skills that are involved in being a lawyer. You interact with a lot of people. If you're in litigation, you've got both people in your office, secretaries, paralegals, the guy in the mail room, the guy in the copy room. You've got other lawyers in your office. You've got investigators from various law enforcement agencies that you deal with. You've got court personnel that you deal with. You've got witnesses that you deal with. Lots of people you interact with on a daily basis. And how you do in those interactions is very important. And you talk to people, other lawyers on the phone, and you interact with them. Those are skills. I mean, those are things. So when you do, at the beginning of, I think it's the second year where you do this course about counseling, you're going to be doing simulation exercises about interacting some of those contexts. Those are very important skills, those kind of people skills of interacting with people. I was surprised with the prosecutor job how little of it was courtroom. You think of, like on the TV shows, the courtroom scene or the appellate court scene, and a lot of what prosecutors do is outside of that context. Some of it surprised me in the sense of investigations, that very often in the federal system especially, you're involved in the investigation of a case, of helping plan it, and you're a legal advisor, and some of the time you're just giving your 2 cents about how to do an undercover scenario or something, and they don't teach that in law school, at least not where I went. And so a lot of it is common sense, and you kind of learn on the job, and that was kind of a surprise to me, being asked my opinion, and then going out into the field and interviewing witnesses along with the agents. And it was very exciting, and it was fun. So that was a surprise. The other thing that came as somewhat of a surprise, although I should have known this, is 90-some% of all cases in the federal system, and it's almost close to 100%, the cases end by a guilty plea, not by a trial. And what it means is a lot of what you're doing is negotiating guilty pleas. And so for those of you who you're taking contracts, contract law is actually very important to that process. So pay attention, in the contracts classes, because those principles are very important, because essentially that's what you're doing with a guilty plea, is you're negotiating a contract, and contract principles basically apply. But that's a lot of what you do as a prosecutor is work on investigations and then work on guilty pleas. and then it's kind of the tip of the iceberg is the trials and the appeals, and you know, actually having cases go to court.
Well, those are, I think that's all good information and good guidance, but I'm going to make you tell one story so that you can help the students know how to deal with their first day of their first trial and maybe what to do and not to do. Can you tell them about your morning, the first day of your first trial as a full-time AUSA?
Well, the thing to do is to have better luck than I did. It's amazing that this happened, but I was walking to the federal courthouse in Chicago. It's a high-rise building on the day of my first trial, and we were going to do jury selection that day. And I was, of course, very nervous and got up very early and put on my best suit and of the 3 or whatever that were in my closet, and tried to look presentable, and went to the parking garage and was walking into work, and I'm going by a German restaurant called Berghoff, which was right around the corner. And early in the morning, they were offloading barrels of beer, metal barrels. You can see where this is going. And what happened was they would drop them out of the truck onto a deflated tire, which they would use as a pad. And one of them missed the tire, hit the curbing, and the seam broke. And there was this jet spray of beer. You can probably tell from looking at me, I'm not much of a dancer, but what I did under the situation, I was able to kind of jump up and over the stream the first couple times it came by, and the third time it got me, and I was drenched in the lower part of my legs with beer, and that was the day I learned that you should always have in your office an extra change of clothes, and maybe even shoes, in case disaster strikes. So I went through the whole day reeking of beer. And the embarrassment started when I got on the elevator to go up to the 15th floor, and right before the elevator doors were about to close, the guy who was the first assistant, who's like the number 2 guy in the office, gets on the elevator. It doesn't take him but 15 seconds to start sniffing and say, what the heck is that? And I had to try to explain to him in my panic state what it was, and he didn't seem to believe me very much. But and then all day I was trying to stay away from the judge for fear that she would smell of the beer on me. She knew it was my first trial, so she was encouraging me to participate, and I was trying to stay back. So it was a long day.
Well, there's some good lessons there. You did this a good while, and obviously you've still been involved over the years, even while you've been teaching. What did you like about it? What gave you the satisfaction and joy you had in that particular kind of job?
Obviously, different people like different things, right? I went to school with the guy I mentioned, who wanted to be a tax lawyer, and now for 30 years he's been a tax lawyer, and he must like that, I assume. I don't think I would. I think the easiest and simplest answer is it was fun. It was challenging. There are moments when you lose sleep over difficult issues that come up. There are, confrontations that occur. Trials are kind of combat some of the time, and it's not like it's a stress-free kind of fun, but it was very satisfying. It's public service, and which roughly means, you make a lot less money for doing the same quality work as people in the big firms who are making a lot of money. But that, to me, was satisfying to be able to do that. And there's a reason why people watch cop shows, right, and lawyer shows on TV. The reason that they have good ratings, like Law and Order, is that a lot of people just find it inherently interesting to watch the drama play out, and you get to participate in some of those things, and it's fun. It's not without its challenges, and there are very difficult moments that come along the way, but that in a nutshell is why I enjoyed it and continue to enjoy it so much.
Okay, I'll bite. Talk about the challenges.
Okay. You're getting a sampling of it here this week. I mean, some of these things you've been reading about, and don't get the idea that every case turns into some huge moral dilemma. But there are ethical challenges that come up. Some of them relate to the law, like you read this story in the Pink Room, which deals with the so-called Brady obligations to turn over important exculpatory or mitigating information to the defense. And that's an obligation that you have as a prosecutor under the Due Process Clause. If you don't do it, like the prosecutor in that case didn't do it, I mean, you're violating someone's constitutional rights, that defendant's rights. And that guy ended up spending a lot of time in prison. In my opinion, reading that story and looking at the information there on the cases, that was really not a prosecutable case if all of the exculpatory information, the damaging information about that child witness is known. I'm not even sure that one goes to court if all that information is on the table. And so you deal with that now. I always thought that was relatively easy in some ways to deal with, because you just have to accept that's part of your job to do it, is to turn that over. Because you represent the government, you represent the public, and you have a different role than a defense lawyer. Your role is to do the right thing. And some of the time that means you're not going to win the case that maybe you hoped and maybe even think you should win. But you have to turn that information over. And in counseling and supervising people, they come to me and say, well, I found this information. I don't think it's important information. I'd rather not turn it over. To me, that was very simple. If you really think this information can't affect the outcome of the case, if you have the courage of your convictions about that judgment, then turn it over. Why not turn it over? Can't affect the outcome of the case. If you're really afraid it hurts your case, if your gut is telling you, oh, I know how the defense lawyer could use this could hurt our case, then that's the barometer to tell you, you need to turn that over. Turn it over. Don't worry about whether it's necessarily going to change the outcome of the case or whether there's a reasonable probability or whatever the language is. Turn it over and take that course and know that you're doing the right thing by doing it. And then if you believe in your case, go litigate the case and hopefully win. But you run into those. Brady is one of the things that recurs. But there are all kinds of things that come up. I'll just throw out one other example I was thinking about the other day from many years ago. And this doesn't really have to do with the law. This is just kind of a moral/ethical question. Dealing with witnesses. I can remember a case where I had a witness who was a Chicago policeman who had gone bad. He had become corrupt, and he had some of his own mental health problems. And during a leave of absence from his job on the police force, started in with some drug dealers, and he was delivering drugs for them and carrying weapons during the transactions, and he got caught. So he had this fall from grace. He went from being a Chicago police officer to being a convict, basically. And he pled guilty, and he agreed to cooperate with the government, and he was my witness. I was going to put him on the stand. He was very fragile psychologically, and he was needy. He was a proud man, he had family, and he had had this terrible fall in his career, and he was looking for some friendship, really. And I was really about the only thing on the horizon. And of course, we weren't buddies, but he would be brought to my office when we would be working, and it was a question of keeping him in a good frame of mind so that he could testify effectively. And I thought about that and worried about it. And I thought about it since of where's the line between being completely professional and manipulating somebody to get them to do what you want. And, is it okay to be insincere of chatting up with the guy and pretending to be real interested and pat him on the back and encourage him when your interests are really selfish for your case to make him a good witness. I struggled with that some. I mean, I'd like to think that I was being, extending to him human kindness, which was something that he needed at the time. But I also worried about the extent to which I might be playing the guy to get him to do what I wanted him to do, and which he did quite successfully. And so those are the kind of little things that come up from time to time where you have to kind of sit back and kind of think about what you're doing. It's an area of law, both defense and prosecution, where there are a lot of those little issues that come up you have to think about.
Let me go back particularly to Brady for a minute, because that's the one part of this process that the students have been exposed to. You and I both know that this has been a very hot issue over the last several years. There are a lot of high-profile examples of prosecutors who have knowingly disregarded this obligation. And I wonder if you could talk about, not trying to forgive, not trying to condone, but just trying to understand, what would lead a prosecutor in those circumstances or in the pink room, what would cause them to disregard a constitutional obligation that is at the core of their job as a prosecutor?
Mm-hmm. Well, as you learn from reading that chapter, the legal standard is that you don't have to, under the law, turn over everything that could help the defense. You have to turn over what the law says is material, which means it's of such significance that it potentially could change the outcome, could change the verdict, or could change the sentence in the case. And so I think what happens to some prosecutors is they believe in their case, they believe they've got the right person, they believe that conviction is going to be the right outcome of the case, and when they see a piece of evidence that could help the defense, they rationalize it, and they say, well, this couldn't possibly change the outcome because I know the right outcome in the case, and so it's not material in my judgment, and so I'm not going to turn it over. Now, as I said before, my philosophy as a supervisor and as a prosecutor was to turn over almost everything that's exculpatory, to err on the side of disclosure, on the theory that if it isn't material, it's not going to affect the outcome by definition. So that was the way I did business, and encourage people to do business. But some prosecutors, I think, say, no, I'm not going to do the defense lawyer's job for them. I'm going to be a zealous advocate for the prosecution, and so I'm only going to turn over material information, and then they have a very skewed, biased view of what is material. Some of this, I think, comes from management and culture in an office. When you walk into a prosecutor's office, when I walk into one, I can almost tell instinctively what the culture of the office is. Is it an office where we're going to do the right thing, we're going to do it the right way, or is it an office that says we're about locking up the bad guys, and we don't really like defense lawyers, and we're going to be aggressive and to lock up all the bad guys. We're only going to turn over what the law says we have to turn over, and not one morsel more than that. And I think if you get into that kind of a mindset, you can end up doing things like that prosecutor in the pink room story, where they apparently had this information, which was unbelievably exculpatory about this young witness, and rationalized somehow, we don't think it's important enough to turn over, we're not going to turn it over, and our failure to turn it over didn't change the outcome. And it can happen. In the federal system, there was a very high-profile case, prosecution of former Senator Ted Stevens, where there was a lengthy report that was done about it, and it's shocking what those federal prosecutors rationalized to do. So you have to be kind of careful of the environment. One other thing I wanted to throw out is, I mentioned defense lawyers a couple of times. let me share with you my kind of philosophy about this. I've done some defense work. I think that if you're going to go into criminal law and you're going to do prosecution work or defense work, or maybe over time some of both, I would not look at the two groups of prosecution and defense like two warring tribes. I think you want to, or two teams of which, or two gangs, where you have to be, you have to pledge allegiance to one or the other, and once you get the tattoo of one, you can never convert over to the other. I think that's a huge mistake, a huge mistake. I think they're both incredibly important to the system. I know people who have done on both sides and both borders, and I think that's the way to look at that, is that it's both sides have a hugely important role to play. They're a check on the other. You can do both over the course of your career. And I would avoid the mentality, and I've been to conferences with prosecutors and defense lawyers, and they are rah-rah for their side, and the other guys are bad, and and I understand that. I mean, that's the way we motivate high school football teams too, right? As we tell them, the bad guys over in the next county, they dissed us, we're going to get them, that kind of thing. You can't trust them. Well, I would try to minimize that and avoid it. And try to look at both sides as contributing in an important way to the system, and to be able to do both over the course of your career if you choose to do it.
And in fact, I think in part as a reflection of your view on that, in our LLM program, we train the defense lawyers and the prosecutors together in the same room. Mm-hmm. Right? And I think that's been an important thing for the success of that program.
Yeah, that was an outgrowth of those of us who kind of had that philosophy I just mentioned to you, that we thought, well, if we're going to run a program for training federal criminal litigators, let's run it on that model where they work together. And frankly, it's in your self-interest to think that way, in my opinion, because if you can, as a prosecutor, learn to think like a defense lawyer, you're going to be better at your job. If you can analyze your case and really see how a defense lawyer would come at it. I know I've mentioned this to Pat, that I had a very important mentor in my career who was a prosecutor several years ahead of me in the U.S. Attorney's Office. He was a career prosecutor. He now is in the private sector doing civil litigation mainly, but he's the best defense lawyer I ever met. And he never worked as a defense lawyer. He was a prosecutor. And when I had a case, I would go to my friend Dean and I would say, Dean, what do I have to do to win this case? And he would see stuff in the case, weaknesses that I never saw. He would see weaknesses that the defense lawyers never saw. And he was really, really good at it. And I learned that, when you're a prosecutor, it is such a gift to be able to think like a defense lawyer and to be able to see what's coming. If you're so blind and you're so wrapped up in the righteousness of your cause, you're not thinking like a really good lawyer.
I've got a lot more to ask you, but I'm watching the clock and I'm going to give the students a chance. So before I ask anything else, let me open it up. Any questions from you all?
How would you deal with pressure? There's going to be always someone that is not going to be happy. Maybe a politician, maybe someone that is bad, that can tell you I'm going to hurt you or your family, or try to obtain what they want. How would you deal with that?
Right. Well, let me first, and this is a question I've heard a lot, and it's not a surprising question.
For purposes of the tape, can you repeat the question?
Yeah, but she was talking about the pressures, and I heard several referred to. One was that when people are unhappy with your decisions and they're unhappy with you because you have to make decisions, and then also she was asking about potential threats against people who are prosecutors. Let me deal with the second one first, and this may not ring particularly well the day after there was this report of a prosecutor in Texas getting shot. But the reality is, it is not a physically dangerous job. There are instances that arise, but there are instances that arise in a lot of litigation, even in the civil side, where there's some of that. So I wouldn't worry that, it's like an armed camp where you have to be looking over your shoulder all the time. There are cases that happen where there are real threats that occur, but they usually are taken care of and investigated very thoroughly, and people end up safe. So there are episodes that happen, but it's not something you feel on a day-to-day basis, at least not in my experience. Now, on the other side, which is much more common, you make decisions, you have to sometimes confront people, they're going to plead guilty in a case, you're delivering bad news. And I can tell you, sitting across the desk from someone and saying, you're going to jail for a long time, that's delivering the bad news, right? And they don't want to hear it, and their family doesn't want to hear it, and they might think, oh, you're a bad guy because you're doing it. There is some of that happens. But it's also one of the interesting things about the job is that that's why it's a public service, is that someone needs to make the decisions and deliver the news and litigate the case, and that's something that hopefully is a benefit to the public. So in any kind of law job, you're going to have some of that happens, but it's not something that makes your life miserable, at least not in my experience.
Other questions? Way in the back, yes, sir.
What does a typical work day and work week look like as far as the amount of time to spend doing the different elements of a lawyer's job?
Again, just for the sake of the recording, the question is, what's a typical day, work day and work week in the life of a prosecutor?
It varies. If you're prosecuting cases in court on a regular basis, a lot of it depends on whether you have cases coming up for trial. When you have a trial occur, it pretty much is all-consuming. I mean, it's a lot of work, a lot of hours, and it's pretty much everything is devoted to that. When you're not on trial, things slow down to some extent, and you usually immediately after the trial have to return a lot of phone calls that you couldn't return during the trial, and you do a lot of routine work, drafting indictments, writing up memos for proposed prosecutions, doing grand jury work where you're bringing witnesses in to testify in an investigation and that kind of thing. So it's also going to vary by office as to kind of the culture in the office. Some offices are they're government offices where it's basically, a 9-to-5 kind of job during the week. And then when a trial comes along, it's going to be extra and you'll be working on the weekends some. There are some offices that have a culture more like a big law firm, where even though they're not billing hours like a law firm, they're working a lot. The office I was in Chicago fits that description. So it would be fairly rare that you wouldn't be in or at least working at home on weekends. And the days are often pretty long. Especially when there's a trial or something that you're working on that has a deadline. So it can be a lot of work, and of course you're making a government salary and not a private sector salary. You're not billing by the hour. So every hour that you work more than your quota, you're actually making your pay less by division. But it still is very satisfying, and it's fun work. I mean, I can tell you that I had a lot of buddies in law school who thought I was kind of crazy to go to work for the government because they wanted to work for a fancy law firm. And there's nothing wrong with that work. It's honorable work. But that's what they wanted to do, and they thought I was nuts. And I got a bunch of phone calls 1 year, 2 years after I started working from my buddies saying, so how did you get that job? Where they'd be at their law firm and they'd close the door and they'd call me and say, hey, the honeymoon's over. I'm working like a dog in this law firm and I'm not having any fun anymore. I'd really like to do what you're doing. And so there's a when you're figuring what line of work you want to go in and the pay front, it seems to me you have to factor in quality of life and how much you enjoy the work that you're doing.
Yeah, which is, of course, an echo of what Professor Sammons and Professor Floyd talked about in terms of intrinsic versus extrinsic rewards for your work. Other questions? Yes, sir.
Can you talk about your process for what standard you would adopt when you were filing on your desk as a prosecutor to how you move forward to charge work? good enough and whether you're personally convinced by it.
Okay.
What standard you personally adopted for whether the case would be prosecuted, is that fair?
Right. Yeah. Getting the legal standard for filing a charge is very low. It's probable cause, which if you haven't studied it already, you'll learn is quite a low standard. As a practical matter, that's not the standard for deciding on actually filing a charge. That because you have the burden to prove all of the charges beyond a reasonable doubt, to me, the proper standard for a prosecutor in filing a case is whether they believe that they can prevail under that standard at trial. Now, sometimes there are close cases where, or maybe there's a chance of further investigating the case after the charge and finding additional evidence, but that basically, I think, has to be the standard, because it's a serious step to bring a charge against someone. I mean, even just the charge has a lot of consequences for people. So that's the standard now, in terms of belief in it, right? You, I think, read an excerpt from Justice Sotomayor's book where she was recounting an episode as prosecutor where she didn't think the case was sufficient to prove, and she basically said, I won't do it. And I think that's the right reaction. If you really believe that the case, can't be proved at trial, then you don't want to be in the position of going into the trial and arguing, oh, ladies and gentlemen of the jury, we proved this beyond a reasonable doubt, when you don't believe it. Because and in most offices, if an assistant district attorney or U.S. attorney says, I don't believe in this case, they will relieve you from working on that case. And they'll either get rid of the case or they'll give it to someone else. But that's something that is kind of an occupational hazard that happens from time to time, that people will say they don't believe in the case. And I think only an office with a really, really bad culture would say, well, you have to go do this case anyway, or you're going to get fired or your career is going to be hurt.
Other questions? Yes, sir.
As a follow-up to that, this last week we had to read an article about a DA or an assistant DA rather, who went through the case when he was told not to, or when he was told to go ahead and go through the case and he didn't believe in the case. He made it very favorable for the defense to win. In a situation where you do work in an office where they say, even though you don't believe it, go through with it, what would you give up? What kind of advice would you give to someone like me? Or
What would you have said to Mr. Bibb and Mr. Morgenthal's office?
I know that story, the one that you're referring to and the rest of you have looked at. I don't approve of what he did there, because although you obviously want to get the right result, if you're going to court representing the government in court, the state or the federal government in court, I mean, you have to be a zealous advocate, that you've got an ethical obligation to be a zealous advocate for your side. Now, prosecutors have to balance being a zealous advocate with seeking justice. And in that case, I think the scales tip the other way, where what he was doing was saying, well, okay, I'm getting the right result, but I'm going to do it through tanking, the case. And it seems to me the proper thing for him to do would be to go into the supervisor like Sonia Sotomayor did and said, I'm not going to do this case because I really don't believe the proof is there and that it should be a conviction. Now, I think his comeback to that was, well, if I'd have done that, someone would have just gone to court and won the case. Well, if he really believes that, what does that say? I mean, I think his proper step was not to tank his responsibility to be a zealous advocate, but to go within his office and get off the case.
We've got time for one more. All right, then. Oh, one more.
You talked about how you can't have it, that the relationship between prosecutors and defense attorneys should really be adversarial. Do you think that there needs to be even more cooperation? Because if at the end of the day, the end goal is to see justice done,
right,
is it really fair if, say, you have a defense attorney who just completely misses a piece of evidence because maybe he's just a bad attorney? Should people be punished they got a bad defense attorney.
Yeah.
To what extent can you take advantage of the incompetence of opposing counsel?
Yeah. There are a couple things there. One is although I'm in favor of civility and I'm in favor of not having like this kind of tribal hatred between the two, I certainly wouldn't want to go as far as to say it's not an adversarial process, because it is. And as I said before, it's a battle when you go, but it's done respectfully and as civilly as it can be done. In terms of this issue of kind of taking advantage, let me tell you one little practical aspect of this, and that's that very often when the other side, the lawyer on the other side isn't very good, and I'll tell you when this really happens, people have a constitutional right to represent themselves, even if they're not a lawyer, okay? They're often really bad in court, right? And you say to yourself, well, that's my dream matchup. Me, the lawyer, against the person who's not the lawyer. Be careful what you wish for. Because what happens either with a bad lawyer or a person representing themselves is a jury will feel bad, and they'll think, well, that lawyer, it doesn't seem as good as the prosecutor in this case. Or that person's representing themselves and they're overmatched by the prosecutor. And sometimes that can hurt your chances of winning the case. Now, in terms of just the ethics, it seems to me if the other side will sometimes make surprising judgments that you think are not all that competent, you wouldn't do them, but they may well have reasons for doing it. And so you have to kind of let the adversarial system work. Now, would I say you would never help them in some way if you're the prosecutor? I would say no. It's possible that you could help out the other side in one way or another. I've had defense lawyers actually tell me something that I was doing that was distracting and set me right, and they were just being nice. And that occasionally niceness does break out even in the middle of a trial.
Jim, we could do this all morning, but we're out of time. Thank you for being with us.
Thank you.